This is Barry Zalma speaking for Claim School Incorporated with another true crime of insurance fraud video. This one number 72, entitled Levon Sogomonian versus Imperial Casualty and Lloyd's. Since I began writing these stories that make up the true crime videos in 1990, I have changed the names of the parties to protect the guilty. This is an exception because it involves a decision of the California Court of Appeal. In 1981, Levon Sogomonian, a person who claimed to be a refugee from Soviet Armenia, purchased a homeowners policy from Imperial Casualty. Simultaneously, he also purchased a personal articles floater from Underwriters at Lloyd's, London, insuring him up to a limit of liability in excess of $2 million for the loss of his house and its contents. Shortly after receiving the policy, an arson fire occurred, destroying the house and its contents. In fact, there were two arson fires because the fire department put the first one out too quickly, and to totally destroy the house, a second fire was set. On investigation, Mr. Sogomonian's insurers proved that he had lied on the application for insurance to Imperial Casualty and the application to Lloyd's. The Superior Court eventually, after much litigation, depositions, and discovery, granted the insurer's motion for summary judgment. The Court of Appeal affirmed the insurer's rescission of the policies from their inception. Mr. Sogomonian appealed, and that decision is reported as Imperial Casualty versus Sogomonian, 198 Cal.App 3rd, 169, 243 Cal Reporter 639, a 1988 decision. He also appealed to the California Supreme Court, who refused to hear the case. The appellate court, noting that the trial court failed to determine how much money Mr. Sogomonian owed to the insurers as a result of his fraud, sent the case back down to the trial court for a determination of the amounts owed by Mr. Sogomonian. Judge Miriam Vogel, now Justice of the Court of Appeal, tried the case without a jury. Mr. Sogomonian contended that he should not be obligated to repay any funds to the insurer. He claimed the insurers acted in bad faith by losing the debris from the fire Sogomonian valued at $2 million. Imperial and Lloyd's had, to protect the evidence, collected all of the debris of the personal property destroyed in the fire and stored it at a Beacons van and storage facility for 5 years at great expense to the insurers. Sogomonian claimed the loss of the valuable debris was a malicious act that should deprive the insurers of any reimbursement. After hearing several days of sworn testimony, Judge Vogel made the following conclusions. Quote, "The fire at the Sogomonian residence was an arson that was probably committed by or at the direction of Mr. Sogomonian. After viewing the debris at Beacon's van and storage, she concluded that nothing was missing, and even if it was missing, the debris was valueless, and Mr. Sogomonian was required to reimburse Imperial and Lloyd's for all of the money expended by them in making advance payments, making payments to innocent mortgagees, and for attorney's fees and costs incurred in the declaratory relief action, a sum in excess of $500,000. Mr. Sogomonian, in a cross-complaint against his insurance agent, managed to convince that agent's insurer to pay the damages in exchange for a release of the agent. Sogomonian, however, was unwilling to acknowledge his loss. He was angry. He desired retribution. He concluded that his loss of the $2 million he expected to make from his fraudulent insurance claim was due to the activities of the investigators retained by Lloyd's and Imperial, the late Leslie M. Schifrin of Schifrin, Gagnon, and Dickey, or SGD, Inc., in California. Sogomonian filed a lawsuit in propria persona, that is, acting as his own attorney, in Los Angeles Superior Court, naming Mr. Schifrin and his firm as defendants. Sogomonian alleged that Mr. Schifrin had converted, lost, or stolen $2 million in valuable fire debris that Judge Vogel had decided was not lost and had no value. Mr. Schifrin hired counsel to defend himself and his firm from the frivolous lawsuit and obtained, after spending more than $10,000 in attorney's fees, a judgment in his favor. Mr. Schifrin and his counsel concluded that Mr. Sogomonian should not profit from his wrongful activities, and therefore filed a complaint with the Superior Court accusing Sogomonian of maliciously prosecuting the lawsuit against Schifrin. At the first settlement conference called, the settlement judge was livid. He advised Mr. Sogomonian from the bench that his actions in suing Mr. Schifrin were despicable and an absolute misuse of the judicial system for the sole purpose of revenge. He advised Mr. Sogomonian to settle for any amount Mr. Schifrin was willing to accept. Sogomonian responded that he, not Schifrin, was the victim and that Schifrin had stolen his merchandise. The judge threw up his hands in desperation and closed the hearing. On June 1, 1994, after several continuances, because of Mr. Sogomonian's alleged ill health, the case was scheduled to come to trial in Van Nuys Superior Court. The day before the trial, a check arrived on counsel's desk for the amount of Mr. Schifrin's demand. The trial did not go forward. Mr. Schifrin, after receiving 3 death threats and 13 years of spurious and frivolous activities by Mr. Sogomonian, received a small amount of justice. The lawyer who advised Sogomonian to file the original suit failed to appear for trial because he was in jail for exchanging shots from his pistol with a person who owed him legal fees. Fortunately for the lawyer, he and the person who owed him fees were bad shots and no one was hurt. It took 15 years of investigation and litigation from the date of the fire until the last case closed before justice was done to a person involved in a fraud, only to find that Mr. Sogomonian was able to purchase a homeowners policy without disclosing the fact of the previous rescission of the Imperial and Lloyd's policies, without ever explaining to his insurer that he had been found to have been either the arsonist or the person who called for the arson, and that insurer, rather than fight, paid Mr. Schifrin. So Sogomonian basically got away with his crime. This is evidence, however, that an insurer that decides, once it has sufficient evidence to establish that a fraud has been attempted, to take the case all the way to the California Supreme Court and to defeat all further acts of litigation. If you are really interested, run Mr. Sogomonian's name through a litigation database and you will find that he has filed dozens of lawsuits since immigrating to the United States. It's important that people fight insurance fraud. that insurers refuse to pay frauds and that they fight all the way to the California Supreme Court, as did Imperial and Lloyd's in this case. They should be commended, and the courts who allowed him to commit the crime of insurance fraud only to have a judgment paid by an insurer should have recommended that the district attorney file criminal actions against Sogomonian. They did not. And as far as I know, I haven't heard from him in many years. He is probably still around enjoying the wonders of freedom in the United States. This video was adapted from my book, Insurance Fraud Costs Everyone, which is a supplement to my treatise in 2 volumes, Insurance Fraud Volume 1 and 2, second edition, all of which are available as Kindle books and paperbacks from Amazon.com. If you viewed this video on Rumble, please click on the Rumble button, and if you view this video on YouTube, please click on the like button. Thank you for your attention.